Hi, my name is David Holt, and this is the screencast for Advanced Legal Research, Intellectual Property, Introduction to the Patent Filing Process, Examination, Claim Construction, and Formalities. As an introduction, let's very briefly go over the historical antecedents to the modern American patent legal system. There were developments in Europe as early as the 15th century that influenced Article 1, Section 8, Clause 8 of the American Constitution. Some of the major statutory revisions since then include the Sherman Antitrust Act from 1890 and most recently the America Invents Act from 2011. The American Invents Act is notable for having moved our system from a first to invent to a first to file. This harmonized America with the rest of the developed world, which had already adopted the first to file requirement. Okay, inventions that are patentable are listed in Section 101 of Title 35 of the U.S. Code. It says that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter may obtain a patent. Let's go over some of the elements here. So whoever implies that there needs to be a person who made the invention. Invents or discovers implies that there cannot be prior art, that it is truly novel. Useful is the utility requirement for patent filing. And then process, machine, manufacture, or composition are the categories that are eligible for patent protection. We have three basic types of patents. The utility patents are the most common, and that's followed by design and plant patents. So again, there's a novelty requirement to be eligible for patent protection. An invention must be new at the time of discovery. If it's disclosed in what's called prior art, then the invention is not new nor not novel and may not be eligible for patent protection. Another element is that the invention must not be obvious to one with ordinary skill in the subject matter, and that it has to have some utility. The product or process must in fact be useful. However, we'll see that the courts are very generous in how they apply the utility requirement for patent filings. Okay, as an overview, based on 35 U.S. Code 101, the categories of utility patents are process, machine, article of manufacture, and or composition of matter. However, there are some limitations. Some of those include abstract ideas, mental steps, algorithms and mathematical formulas, and any naturally occurring product, even if its existence was unknown. You may be asking yourself right now, how do companies protect their intellectual property that are algorithms or abstract ideas or mathematical formulas? Well, they may not seek protection under the patent schema. They may rather do that under trade secrets, which we're going to discuss later on in the semester. Okay, patent prosecution. Patent prosecution is the process by which patents are examined by the USPTO and acquire protection. The patent filing process is governed by the USPTO. There is, however, a document called the Manual of Patent Examining Procedure, which governs this process. The Manual of Patent Examining Procedure is available on the USPTO's website. It goes over the examination process and is instructive to applicants as to what their potential remedies are for adverse decisions from the examiner, whether they can seek administrative review or reconsideration of their patent claims, and once they've exhausted administrative remedies, whether they can pursue a remedy with an Article 3 federal court. Drafting the patent application can be a very complicated process. The applicant must fully disclose the invention. This can be highly technical depending on what the subject matter is. I have a photo here of Faber on Mechanics of Patent Claim Drafting, which is published by the Practicing Law Institute. I recommend taking a look at these materials. They are available on Bloomberg. And so if we navigate to Bloomberg here and then go up to Practice Centers and then down to Intellectual Property and then Patent Law, and then PLI Patent Books and Treatises, you'll see that Faber on Mechanics of Patent Claim Drafting is here, as is Patent Claim Construction and Markman Hearings, Patent Law Practitioner's Guide, and materials on patent licensing and litigation. Okay, once the applicant has filed, the USPTO begins the examination process. The examiner is going to be looking for examples of prior art, and will also be classifying the patent filing based on its subject area. This would be a good time to dive into an actual patent, and so let's take a look at both the USPTO's website, and there's also a Google search engine for patents. If you type in patents.google.com in your web browser, you'll be able to locate the patent search engine provided by Google. I'm going to enter in a search query here for cat massager, and you'll see that there's a number of patents that have been approved by the USPTO dealing with how to massage a cat. So again, that usefulness requirement can be broadly construed by the courts. Some of the elements that I want you to notice here: the abstract of the patent filing, the classification schema, and these were assigned by the examiner with the USPTO's office, a description of the invention and what's being claimed. And if you scroll all the way down, you can see that the patent has been properly maintained and that other patents have cited to this patent. If you click on external links here to the USPTO, you'll see this same information on the USPTO's website, along with the images and exhibits that were included with the filing. Okay, let's also go over some of the major materials that you're going to have, that you're going to utilize for the upcoming patent law assignment, which is going to be due on the 28th. Here on Lexis Advance, you'll have a number of treatises that are going to be available to you. The big one, however, is going to be Chisholm on Patents. Chisholm on Patents is a highly regarded secondary source on patent law. It's cited by the courts rather frequently. The equivalent to Chisholm on Patents that's available on the Westlaw platform is Walker on Patents. I should point out, however, that this treatise, in addition to a number of the other treatises that are available on Westlaw, are considered less authoritative than those that are on Lexis, and this is particularly true for intellectual property. So we have Nimmer on copyright available on Lexis. We also have Gilson on trademarks, Milgram on licensing, Horowitz on patent litigation. Those sources are considered considerably more authoritative than their equivalents on Westlaw. Okay, let's do a quick overview of the materials that we've already covered in the course. Obviously have already gone through week 1, which dealt with query formation and research strategies. A few of you were struggling pretty badly with the Boolean logic, proximity indicators, and segment searching assignment, although you've all improved dramatically since then. However, if you do want some refreshers on that, I've posted the documents from both Westlaw and Lexis dealing with segment searching. I was very pleased with the submissions I received for the 2 copyright assignments. And then for the patent law exercise that we have due a week from now on the 28th, you will be looking at an actual case that was filed in the Northern District of California. I want you to be able to pull up the docket for this case on Bloomberg. Now, Bloomberg is extracting these materials from PACER, which is the electronic filing system for the federal courts. After you have located the docket sheet, I want you to locate some model jury instructions that would be useful, some secondary materials, so encyclopedia entries, legal scholarship, also some case law that would be helpful, and then the relevant sections from both Chisholm and Walker that would be helpful for this case. And then the rest of the assignment, I'm asking for model documents. And if you are confused as to what model documents are going to be available to you, I suggest you look at the screencast on practice materials that I posted for the first week. If you haven't viewed that screencast, I highly encourage you to do that. If you already have seen it, I encourage you to go watch it again. It's going to go over the types of form books that are available to you on both Lexis and Westlaw. We're going to be looking at model complaints and answers that would be applicable for this cause of action, model interrogatories, model motions, and then for the remainder of the assignment, we're going to be working within Wright and Miller's Federal Practice and Procedure, which is considered pretty much the Bible for federal procedure. If you have any questions about last week's assignments or the upcoming week, please don't hesitate to email me. My email address is dholt@scu.edu.